Don't know whether it's about funding and so forth, but I'm now requesting, depending on what the judge, what your lordship says, we shall then take the matter further with our head office.
Is this a request in coming from the state?
Yes, indeed. I think it's in the interest of everyone, since this trial is not going to finish within this term, and it is going to take time, very long actually, at the rate we're going on.
Yes, I'm concerned about the fact that if there is going to be a running transcription of the proceedings, it might cost hundreds of thousands of rand. And who's going to stand in for that? The taxpayer or who?
The taxpayer.
Me and you.
Indeed. But maybe we can compromise with the taxpayer and say if we can have it transcribed at the end of each month at least, so that they don't have to type it every day, because that is the expensive part. If they have to type what happened in teaching every day, then it's very, very expensive. I know.
Well, who is going to benefit from such a transcription? The first thing that comes to my mind is that I truly don't know, but it might be that some of the accused in the main trial, say for instance, might be found guilty and sentenced. Then they will need the transcription perhaps to go on appeal.
Yes.
For what other purpose do you do?
In court, because we are all human somewhere. Lordship and also foresee
Then new presenters will have to acquaint themselves
The heads were also written in a manner as one would basically speak. It's not only heads of argument that asks for a long verbal argument. So, as far as my heads go, I will stand with what I placed before the court. I shall address the court further in reply, if necessary. I know that my colleague Nicholson also wants to address the court on certain aspects pertaining to his heads of argument.
Thank you, Mr. Zinase. Mr. Nicholson? Nicholson is the surname, isn't it?
Nicholson is the surname, yes.
From Durban of all places.
The Kingdom of the Zulu. My Lord, like my learned leader has just stated, I'm not going to address his lordship very long on the head. I think the head speak for themselves. There's just very briefly, I just would like to make a few comments. This case, my Lord, his lordship, I'm sure is well aware. This case is about jurisdiction. Now, the issue of jurisdiction that is raised here is that this court does not have jurisdiction because the South African government misled the U.S. authorities. And that's the crux of it. Now, if we have to ask why are they saying that? They have raised quite a few issues. The issues that they have raised are issues like flight risk,
the Kenya story.
The Kenya story. I think in the cross-examination they spoke about mental torture. Although mental torture was never pregnant on the 115 statement, it was never mentioned, although it had been mentioned in previous court applications. Now, my submission to his lordship is that this matter is quite simple. The only relevant issue that they have raised in their heads in the 115 statement is the issue at paragraph 4.1 of Exhibit 5. The state lied, misrepresented to the U.S. authorities that there was probable cause for the charges against the accused 17. That's the only relevant issue. The remaining issues about being a fugitive from justice, flight risk, and I think there's another issue about lying about being part of a syndicate. For the purposes of what the courtship is called to hear today, those three issues are irrelevant. And why do I say that, my lord? If his lordship has regard to the extradition ruling, which is at Exhibit 9, divided E, you will see at the extradition ruling, there were 5 issues again that the magistrate's judge, as they call the judge magistrate or magistrate's judge, as they called in the U.S., was called to determine. These issues, my lord, is the judicial officer is authorized to conduct an extradition hearing. The court was subjected. The court has a subject matter and personal jurisdiction over the fugitive. The applicable treaty is in full force and effect. The crimes for which the extradition is requested are covered by the applicable treaty. The 5th one is the only relevant one that seems to be that accused 17 has taken issue with. That is, there is sufficient evidence to support probable cause as a charge for extradition, for which the charge of extradition is sought. That's the only issue. So his lordship, what his lordship must do is determine, not yet today, because in this court, for the child, it's a totally separate question. His lordship, for the child, must determine if there's sufficient evidence to convict, or if there's sufficient evidence, or if there's prima facie evidence to go beyond the state's case. For the purposes of a child within a child, his lordship has to determine whether there was a misrepresentation made to the U.S. authorities with regard to the extradition. on the issue of probable cause. That is all. So it's not whether it's reasonable or probable cause now. It's that does the documents reflect reasonable and probable cause that was submitted to the U.S. authorities, and in those documents did the state lie. Now, the issue of materiality, my lord, was dealt with in my aid of argument at paragraph 19. The case of Tebingela versus the South African Mutual Life Assurance Society. The full citation is in my aid of argument. The issue of materiality as states, what that says, to summarize His Lordship, is that the question doesn't stop whether there was a misrepresentation made. There may have been a misrepresentation. The question is, did that misrepresentation have an effect on the extradition process? So, we deny that we misrepresented she was a flight risk. That had no effect. If His Lordship had come to the finding we misrepresented, that had no effect on the extradition process. Did we misrepresent a Kenya and Nigeria issue? That had no effect on the extradition process. Did we lie about the other issue that they've raised, the syndicate issue? That had no effect on it. So what Taylor goes on to say, a way to accomplish this, the manner in which we should accomplish this, is to compare what was submitted and what we have now, and check if on what was submitted a different decision would have been made. My submission, my lord, is that this issue has never, that issue with regard to reasonable and probable cause has not been demonstrated by way of evidence by accused number 17. So therefore, the court only has the verdict of accused of the state. With regard to, and that's a very important issue, my lord. His Lordship would have noted, His Lordship was, well, no doubt aware that in his ruling, His Lordship said, among other things, two very important things. That evidence must come from the state before His Lordship can make a ruling, and evidence must come from accused 17 as well. That's what His Lordship's ruling. Accused 17 has not taken the stand, has not taken the court into its confidence. We put a witness in the stand, was subjected to, for lack of a better word, brutal cross-examination by both accused 17 and Otis SC, and that's the evidence before His Lordship. There is no other evidence except the version of the state. With regard to the affidavits that are before the court, my submission, my lord, that will I speak of the affidavits of accused 17 in the various applications. My submission is that will amount to inadmissible hearsay, because she was present in court. She could have taken the stand, but she did not. That, my lord, we would see in the case, there's two cases that I quote in that regard. It's the case of, it's S vs. Musa at paragraph 42, and the minority judgment of S versus Davis at page 41, the full citation at paragraph 41. The full citations are there. In Davis, the court said, the court came to the conclusion that an adverse inference can be taken by His Lordship, even though it is the accused, and the accused has a right to remain silent. What the Constitutional Court said on that point was the if there is, both Busak and the Constitutional Court make a similar point. They say that if there are issues that are within the peculiar knowledge of the accused, notwithstanding his right or her right to remain silent, they should take the stand. They have a right not to, but if they don't, the court is entitled to come to an adverse, to make an adverse, to take an adverse inference on the issue. Now, that's important, my lord, for one very particular aspect. It's overall important, but for one issue, it's very important. His lordship had, I think my learned friend, she spent quite a long time on it. What happened when the FBI approached Ms. Charlotta in the US? She says that she was degraded, she felt tortured, she felt intimidated, lots of things that are all conclusions. The facts of those things we don't know. That is within the peculiar knowledge of Ms. Charlotta. She did not take the stand, so we don't know. So what are we left with? We are left with the evidence of Captain Khalid and General Kharba, who said from their observation, everything was fine. So my lord, my final submission in that regard is that on the issue of jurisdiction, it has not been demonstrated that this court does not have jurisdiction to hear the matter, because the issue of reasonable and probable cause has not been penetrated at all, my lord. So my lord, unless it's negotiated anything further, those are my submissions.
Yes, Mr. Nicholson, thank you. I have one question to you, and that is the document under E, tab E in Exhibit 9. Is that the final and the actual extradition order made by the U.S. court?
That's correct, my lord. If his lordship reads that document, you will see that it's in two parts. It's a recommendation made by the judge magistrate, and in the second part is the actual order by the secretary, our Minister of Justice. Our Minister of Justice counterpart.
Are you now referring to the part with the heading of Department of State?
That's correct. That's correct. Lord, may I just take instruction just on one issue?
I'm sorry to keep you waiting. I'm just looking for something because I have a question.
No problem. Is his lordship referring to the issue on which the certification was granted, the charge on which the certification was granted?
Yes, and I'll play open cards with you.
Yes.
I cannot recall where I saw it, but during the course of the proceedings, my eyes fell on a sentence somewhere which says that she's not extradited for purposes of being charged with fraud and money laundering.
That's it, yes, yes. His lordship is correct.
Where do I find that?
It's page 11.
Is it page 11?
Of what?
The second paragraph of page 11.
Of that Department of State.
Of the Department of State. The one with Department of State. The heading for Department of State.
Yes, Department of State.
Page 11 and the second paragraph.
Which ends with the remaining fraud and money laundering charges and specified alternatives to those charges not having been forwarded to the court for consideration.
That's correct.
What does that mean?
My Lord, just to state, my Lord, we're not going to continue with those charges. That is dealt with in my landed leaders' aids of argument in paragraph 3.
Is it dealt with by Mr. Denison?
That's correct. We're not pursuing those charges.
Now she has pleaded to those charges,
Yes.
and according to the provisions of the Criminal Procedure Act, since she has pleaded, she is entitled to either be found guilty or to be acquitted on those charges. Is that correct?
That is correct, my Lord. That
Let
is
me
a conundrum.
let me just look at paragraph 3 of Mr. Denison says. It means that this whole question of whether the court has got jurisdiction is now confined to only certain charges.
That is correct.
Is that is how I saw it in the back of my mind, and I just couldn't put my finger on
Yes,
on
my
that
Lord.
specific. But I'm grateful that I now have it before me.
Indeed, my Lord. My Lord, the mechanics of how this is going to work, I think we're going to have to think about it. His Lordship was quite correct. She has pleaded. So the mechanics of how this is going to work, we're going to have to just think about it.
If I may assist. My Lord, the question is actually very simply answered. It was an oversight from the state. Those 4 counts of fraud that the Americans referred to, which they did not allow extradition on, were not to be put. But it was put, she pleaded on it, and if the main trial now continues, we shall simply just stop the prosecution on those 4 counts. And we are entitled to do that. And that is the end of the matter pertaining to those 4 counts. As it is.
Yes, but well, as far as the trial within the trial is concerned, certainly on the information that I have before me, I will be able, and I should find, that this court has got no jurisdiction to hear those specific charges against the accused. And if I come to such a finding, then it will almost automatically follow that she will be found not guilty and discharged on those counts.
As it pleases the court, the one or the other.
Yes,
As
yes, thank you. Anything else, Mr. Nicholson?
Nothing, my Lord.
Just one other question. You know, the word misleading the court in the US, telling lies to the court in the US, both those words, misleading and lies, have got an element of intention in it. Intentionally misleading the court, intentionally telling a lie. But misleading, do you say that misleading could also mean mistakenly placing certain things before the court without any intention to mislead the court?
Well, That's correct, but we didn't want to go into that because we look at it would just be unnecessary to do so.
Yes, you are relying on the materiality of.
That's correct,
Mm.
my lord. And my lord, the court can be misled innocently, can be misled negligently, can be misled mistakenly. Whether it was intentional or not, we don't have a version from accused 17, so we don't know. So we are just relying on the issue of materiality.
Yes. Thank you, Mr. Nicholson.
My lord, before I sit down, there's just one last issue that I remembered while I was speaking. That His Lordship brought to my attention. That His Lordship reminded me. It was very inappropriately, with respect, I said to General Gerber that Captain Kalitz lied without Captain Kalitz being confronted in court. I deal with that issue at paragraph 74 in the case of Small versus Smith, and I also deal with it at page 75 of President of South Africa, President of the Republic of South Africa, and others, where the court has said it's very inappropriate to accuse somebody of lying when they have not been confronted in court, to put the facts before the court. And the reason is, as I've just mentioned before, people mislead the court, not necessarily lying, but for a number of reasons, by mistake, memory, for a number of reasons that could be. Without that person being confronted in court, we will never know why there's a difference in versions. So it was very inappropriate, and I say this with respect for my learned friend, to have accused Captain Kalitz in that manner without confronting him while he would understand. Those are my submissions.
Thank you. Ms. Macapella? Final submissions on the trial within the trial?
Okay. Do I understand that Advocate Donation would not be addressing the court? Perhaps
He has addressed the court, but he basically stood by his written heads of argument.
My apologies, my lord. I did not get that. My lord, I will address the question of the written oral submissions at the end of my oral submissions, if that is okay with the court.
Yes, have you prepared written heads of argument?
I have, my lord. However, they pale in comparison to what I'm capable of when I'm not ill, which I was this weekend. And so I ask the court's indulgence to hand in the heads of argument either by the end of the day or tomorrow morning. What the current state of my heads of argument are what I have prepared up until last week, Friday, and I wasn't able to during the weekend as I had taken ill. I think Ms. Carpenter was coughing all over me, unfortunately.
Okay, I hear what you say. Ms. Macapella, when you address the court now without heads of argument before the court, are you going to basically stand by your heads of argument? You're not going outside what he said in your heads of argument?
No, my lord. My heads of argument are written. What we need to do is reduce everything to legible form and also look at our transcript. We were recording by an iPad, so we have that in sequential order of the days. So it's just to take what I have written here, as well as the cases that I've referred to, and to extract the relevant sections, as well as to place each witness's evidence back to the transcript. So that's all we need to do, which is why I was talking about the end of the day.
Yes, okay. Are you feeling fit and well to proceed with oral argumenting?
I am.
So I think we will do it then as follows. I will listen to your argument, and after that I will allow the state to reply thereto, and then I will afford you time to get your written submissions ready and to hand it in with my secretary either by the end of this day or tomorrow.
Thank you, my lord. I'm grateful for the court's indulgence.
Thank you.
Is that okay with my colleagues, Selma?
I don't care if it's okay with them.
Okay.
I'm telling you that is how we're going to do it.
As it pleases the court. Lord, I'm going to be quite elementary with my explanation of the entire situation of how we came to the trial within a trial, as well as what we aimed to prove in the trial within a trial. And so it is tried that under South African law, where a person that has alleged to have committed a crime is charged, who is alleged to have committed a crime and charged, is brought before a court of law, as in the present circumstance before this Free State High Court. They have to enter a plea to the charges against them. Ordinarily, what is found is that the choice is between a plea of guilty and not guilty, or rather, more often than not, it is between a plea of guilty and not guilty. However, in terms of Section 106, certain pleas are afforded to accused. And one of those is the plea that we went with, which is the plea under Section 106(1)(f) of the Criminal Procedure Act. And on 16 April 2025, Ms. Cholota was charged with the counts against her of fraud, of corruption, and the alternative charges. Now, as was stated in the brief interaction, or rather brief back and forth between the representatives for the state and the Lord, the United States did not grant extradition on some of those charges. And so what follows from here on is in relation to the charges that remain. And so those would be the charges of fraud, I think 4 counts of fraud, 4 counts of corruption, and the alternative charges. Ms. Cholota reasonably notified the state of her intention to file a plea explanation and a special plea. This was on the 15th of April 2025 when the proceedings began. The plea explanation was handed up before this court, and this was filed under Exhibit 5. In terms of paragraph 4 of that exhibit, the following issues were raised in terms of Section 115 of the Criminal Procedure Act to be tried by this court. The first was that the state lied or misrepresented to U.S. authorities that there was reasonable and probable cause for the charges that were brought against Ms. Cholota. The second was that the state lied or misrepresented to U.S. authorities that Ms. Cholota was a fugitive from justice. The third is that the state lied or misrepresented to U.S. authorities that Ms. Cholota was a flight risk with connections in Kenya. And the fourth was that the state lied to U.S. authorities that Ms. Cholota was part of a syndicate with Mr. Mpambane and that she facilitated kickbacks for this syndicate. In essence, Section 106 has its primary basis on the fact that the extradition, or rather our reliance on Section 106, has as its primary basis the fact that the extradition of Ms. Cholota from the U.S. to South Africa was unlawful. Now, according to the case, the appellate division case of Rex versus Khadebe, 1945 AD 590 at 603, read with S versus December, which we previously referred to, and S versus Mahala. It is the prosecution that bears the onus to establish jurisdiction once jurisdiction is placed in issue. And in terms of S versus Base and Anara, 1994, 1 SACR 539 at 541, the standard of proof is beyond reasonable doubt. And so when we put in issue that jurisdiction was not present, the onus then shifted onto the state, my lord. And it was for the state to prove to this court that it had jurisdiction, and the standard upon which it had to do this was beyond reasonable doubt and not on a balance of probability. Now, we had already argued during our brief arguments for a trial within a trial that the jurisdictional issue ought to be heard and disposed of first. We cited S versus Vellum and S versus Dursley as the authorities, therefore. And the relief that we seek in this trial within a trial is that the extradition of Ms. Chalota be declared unlawful, and that it be declared that the South African Criminal Court does not have jurisdiction to try her of the offences that she is charged with. So that's the brief background. But in order for us to move from the 106F plea, special plea, to the timeline that we contend with the extradition, it is necessary to set certain issues in their sequential form. There were many tabs between here and there in Exhibit 9 that might have gotten the dates muddled. And so I'd like to just specify specific dates and why those dates are important for why we say the extradition was unlawful. It is imperative that this timeline of events be understood in order to gain understanding of how unlawful and unconstitutional this extradition was. Now, my lord, in terms of tab A, we understand that the original request for extradition was compiled by the National Prosecuting Authority on January 2022, and it was forwarded to the United States after the Director General of the Department of Justice certified it and forwarded it to DIRCO. My apologies, I do not know the full citation for DIRCO, but I think it is the Department for International Relations and Cooperation. And so that's January 2022. And then in terms of page 3 of tab B, this would be the letter that the United States Department of Justice wrote to the South African prosecutors. Under that letter, if we look at page 3, the U.S. sent a request for further information on the extradition to South Africa before August 2022. Now, it's important to note that it is before August 2022 because the response by South Africa is dated 18 August 2022. And we'll return to this tab with the next dates. But if after that, August 2022 or before August, we would jump to tab HI, that would be the annexures that are attached to the Constitutional Court replying affidavit that the National Prosecuting Authority filed. Under Annexure AA7, the Director General in the Premier's office, Mr. Kopong Raligonzane, addressed correspondence to Ms. Chalota threatening possible termination of her bursary, and this was done on 16 August 2022. So we've got the initial request at the start of 2022, and then shortly before August, the United States writes to South Africa requesting further information, and we'll look at what that further information entailed. But shortly before South Africa sent its first response in August, Mr. Raligonzane sent his correspondence to Ms. Chalota, and it will become relevant why these two need to be considered together, why these two dates need to be considered together. Now, my lord, it will be recalled that during Captain Carlos's evidence, he testified that the investigators had multiple meetings with Mr. Raligonzane, and that it was them that informed or gave the information to Mr. Raligonzane that Ms. Chalota was uncooperative with law enforcement agencies. This too will become relevant. Now, in terms of the same letter that the United States authorities wrote under tab B, the South African authorities tried once more on 11 October this time, 2022, providing what was termed an amended affidavit by Advocate Dineshan and additional annexures. This is what the letter records. So 11 October 2022. Shortly before October, if we move back to tab HI, Mr. Raligonzane by this time had requested, or rather ordered, Ms. Chalota to present herself before him at the Premier's office by the date, within 10 days of his previous letter, which was late August, wherein she ought to have made submissions to him why he should not terminate her bursary. Now, he then terminated the bursary on 19 September 2022. So, August, the United States wants more information from South Africa. Late August, South Africa gives that information. September, Mr. Ralekontsane demands that Ms. Chilota come to South Africa to meet him and tell him why he should not terminate her bursary. And then in October, South Africa sends the second attempt at convincing United States authorities that their extradition case is viable. That would have been October. In November, my lord, 30 November 2022, again, this is a date that is set out in tab B by the United States Authority. It would seem that Advocate Dinesian's amended affidavit and the annexures still weren't enough to convince the U.S. authorities, because the U.S. authorities in that letter, my lord, say that they then conducted a, quote, conference with South African prosecutors. And they then record, and I quote directly from the letter, ultimately, we were left with open questions as to whether the facts supported the proposed charges. This is on 30 November 2022. What the writer of that letter is saying, even after the resubmission of August 22, that of 2022, on 30 November, the U.S. was still left with open questions as to whether the facts that South Africa provided supported the charges against Trump. This is 30 November. Now, once again, my lord, the letter records, and we're still tab B, the letter 26 January. Once again, the letter tells us that South Africa tried yet another time, and this time on 12 January 2023, to present more information to U.S. authorities. And it records that South Africa provided additional information on the legal analysis of the proposed charges, but did not provide additional factual support for those charges. And so this is on a fourth attempt by South African prosecutors to convince the United States that facts that they had supplied matched or rather supported the charges that they had leveled against Mr. Chilota. That was on the 20th that quoting from was dated the 26th of January, and the United States told them the following. And my lord, we quote directly from the on this score, and that would be tab B. Tab B, page 3, wherein in this of the 26th of January, that would be about the 5th or 4th communication or request for further information that the U.S. sends to South Africa. They state that their primary concern as to the and I'm reading from the 4th paragraph, it's the first paragraph under OIA's preliminary analysis. It stated there that the OI's primary concern as to the extradition request on Ms. Chilota is that it does not establish probable cause that Ms. Chilota in fact knew of or participated in the scheme from which all the charges of indictment arose. They go on to state that allegations against her appear primarily to be based on the fact that she was the Premier's PA, and nothing happened in that office without her knowledge. And there's a footnote 4, and when one looks at that footnote 4, they go on to explain that even if it was sufficient to proceed against her, based on the fact that, quote unquote, nothing happened in that office without her knowledge, the factual allegation is not supported in the material we have received, and so we cannot assume it is true. They go on to state they have not, however, stated any additional factual basis to support the theory that she knew about or was involved in the scheme put forth or approved the fraudulent asbestos removal, or even that she knew it was illegal. So this is after 5 argue for an extradition. The US says this is still not enough. We're still not convinced that the information that you've placed before us sustains any of these charges. On the basis of the Premier's PA, she knew the contract. And so one can assume they, because we have not had sight of the repeated submissions by South Africa, but one can assume that South Africa placed all the information that they had in relation to Ms. Charlotta and the charges before the United States. To withhold information would not have made sense in that instance. Now, this is the letter of 26th January. And this is extremely important, my lord, because it sets up the argument that I'm about to make regarding the extradition. But we have to get to this particular point. All of a sudden, after the letter of 26th January, they arrested 2023. This is an immigration agency called the IC. We will refer to instances in the various affidavits, the various emails where this is dealt with, but it is relevant to the case at hand. Now, my lord will recall that both witnesses, both Captain Kalitz and Major General Gerber, claimed under oath before this court that they had no idea the circumstances under which I was arrested by ICE. So this is the first arrest to tab HR, paragraphs 112 and 113, that, and I quote, he told them that I am aware that in February 2023, Ms. Charlotta was arrested and detained in the USA by the immigration agency known as ICE. I do know all of the circumstances pertaining to her arrest, but I understand that it had something to do with her student visa having expired. And then in paragraph 113, Captain Kalitz also says that Ms. Charlotta's arrest and detention in the United States in February 2023 had nothing to do with the South African law enforcement authorities or the Asbestos project and any trial or extradition proceedings related thereto. Now, the Constitutional Court affidavit is dated May 2024, so this is what he told the Constitutional Court under oath. And then, in August 2024, Captain Kalitz's affidavit before the magistrate, this is under tab S in Exhibit 9, at paragraphs 18 and paragraphs 55, he repeats the same sentence that was stated to the Constitutional Court, that he is aware that she was arrested in February 2023. The state does not know anything beyond that or the circumstances under which she was arrested. Suffice to say, it has something to do with her student visa. Interestingly, at paragraph 55 of the bail proceedings affidavit, he states that I reiterate how that there were immigration-related criminal issues pursued against the United States at some time, but I have no further information in that regard. And so at all times, my lord, this is where that timeline stopped. Up until the state, in re-examining Captain Kalitz, handed up a series of emails that they that were handed up as exhibit 13.11, 13.11. This was exhibits that were handed up by the states. So we have January 2022, August, September, October, November, January when the US writes back, and February when she is arrested. The communication here, my lord, if one has regard to the second last page of those emails, there's an email dated 16 February 2023 from the US Department of Justice's Maria Lerner, the same individual that had been communicating with South African prosecutors. And when one has regard to the second paragraph, my lord, this is addressed to Mr. Dineshan. It says, "Dear Mr. Dineshan," and in the second paragraph, this is what is stated. "I understand your frustration with this situation and will do my best to explain what happened. At your request, and following the presentation to me via email of documents indicating Ms. Charlotta's sponsor had withdrawn their support and she had overstayed her visa, I alerted immigration authorities to this information. This is the Department of Justice, my lord, confirming that the senior prosecutor of the state, Mr. Dinyesha, is the individual that gave them the information that, first of all, Ms. Charlotta's sponsor had withdrawn, and they would have known that because they had been communicating with the Director General, Rali Bonzane, who had indeed withdrawn his support financially. And so he informed them that her student visa had expired, and on that information, she told the ICE, who then arrested Ms. Charlotta. It goes on to say, my lord, that if we recall in the emails that were handed up by Advocate Hopeless, Advocate Dinyesha had also told Mr. Washu that he had no idea why Ms. Charlotta had been arrested in the United States. But this email correspondence makes clear that not only did he know why she was arrested, he was the instigator of the series of facts that resulted in her arrest. Now, it becomes important when the Department of Justice explains why it would be easier for Ms. Charlotta to be deported rather than for Ms. Charlotta to be extradited. And this lays the foundation as to why the state was so desperate to extradite Ms. Charlotta using false or falsely represented information. But we will get to that. If we look at the email, my lord, so that would be the last page of Exhibit 30.7. But I will read to, and these are cited in our heads, but this is what Ms. Department of Justice informed Captain Advocate Dinyesha, that this is the email of 2nd February 2023. Deportation has the advantage that the rule of speciality is not a barrier to what charges can be brought once the fugitive is removed, whereas in the extradition process, a U.S. magistrate judge can determine there is insufficient basis for some or all of the charges and could limit the charges where the fugitive can be extradited. She goes on to say, as long as the deportation order is finalized before the extradition inquiry begins, there is no need to continue with the extradition process, as the deportation order is a legal way to remove her from the country. However, if the deportation process is not completed when the extradition inquiry begins, then the deportation process is put on hold until the extradition inquiry is completed. At the end of her email, she then states that since she is now in U.S. custody, meaning after she was arrested in February, since she is now in U.S. custody, you should have more control over her removal to South Africa than if it had happened on a purely voluntary basis where she could have fled elsewhere. Now then one asks the question, why would she believe that Ms. Charlotta would flee anyway? This is answered, my lord, in the same line of email communication, wherein, and this is the 3rd page, the email dated 2 February, she states that, afternoon, Johannes, I wish I had been informed of the prior arrangements, and then she states that, I recall you had informed me that she was a flight risk to Nigeria, where her boyfriend is from, so I guess there was a danger that she could flee elsewhere. And this is the same email. Now, the timeline of events is important again. At the beginning of 2022, the request for extradition is made. Later on in August, the first request for more information. They say the information that you provide for us is not enough to sustain an extradition. They state that explicitly in their letter. And then Mr. Rali is approached because he then sends a letter that he might terminate the person. Then after that, they ask for more information based on the fact that the previous pieces of information were insufficient. And then Mr. Rali demands that she come back to the country and speak to him within 10 days, otherwise the bursary is cancelled. And then the further. And then now, understand, that after all of this, after Mr. Rali withdrew financial support, Advocate informed the US that she no longer has a sponsor, she no longer has financial support, and her visa has expired. Now, Malone's judgment bears reference here.
because this was a disguised unlawful extradition. But they wanted to achieve these means through deportation, because extradition, as my lord will see with the letter under tab B, needs to follow a much more detailed and much higher level of proof, and they failed the deportation, and they tell us why. Because there is a rule under immigration law in America that as long as the individual is still in school, they may not be deported, which is why they released Ms. Charlotta, because Advocate Nation then asked in the same email that why she released, to which the United States government responds that she was released because she was going to school. Now, in later affidavits, we know, even under the questioning that she was subjected to in the transcript under Exhibit 13, I think it's 13, that Ms. Charlotta had a scholarship with her university, and that the financial assistance of the Free State government was only being used to supplement her tuition. The investigators knew this as well, so they must have forgotten it at some point, because what we can clearly infer from this is that they thought that if they influenced the Director General to put pressure on her to return, that could be one way of securing her voluntary return, or if they put pressure on the Director General to withdraw her funding, that could also be pressure on her to return, because then the authorities would arrest her and then she would have to come back. That basis, my lord, quite apart from the appalling conduct from the state prosecutor, shows us that when the extradition was requested the second time, and this was put back to the state was much higher for the state. They needed more information and more information from these U.S. authorities that the extradition had a valid basis. And so that should be the lens with which every single thing that we argue from here on is viewed through. That they had failed on multiple attempts to get her back to the country using alternative means, such as having her deported, having her come here under the guise of meeting with her, whatever is necessary, all to avoid the extradition process. But when they could not avoid the extradition process, this is what ensued. Now, my lord, in the same exhibit that I've just referenced, there are multiple names of NPA officials that are copied in that email. There's Navila Somaro, the Director for Public Prosecutions in South Africa, in the Free State, and we will recall that it was her affidavit or her request that the original request for extradition was made. There is a Ms. Berenice Claessens of the NPA as well. There's a Mr. Laksen Mgiba. There's a Mr. Lubuyo Mfautu. There's a Mr. Eugene B. Ontong. All of these are members or individuals or staff members or officials of the National Prosecuting Authority. Now, it is quite clear, my lord, everything that has been said in relation to extradition was the National Prosecuting Authority that dealt with extradition. And in proving whether or not this extradition was lawful or not, it was the staff members or the officials of the National Prosecuting Authority which were relevant to be placed before this court, to show this court the process, to show this court the legal proceedings or the acts that were applicable, but it was them that ought to have been here to prove to this court or to show this court that the extradition was unlawful. Not members of the South African Police Service, such as Captain Garlitz and Major General Gerber, who themselves, in their testimonies, distanced themselves from the extradition, stating time and time again that they did not have exact knowledge of the process that was followed by South Africa in asking for her extradition. Time and time again, this was repeated. And so what we know is that the state placed witnesses before this court that were not relevant to the question at hand. So we can then argue that the state has not placed any information before this court in relation to the lawfulness of the extradition. And I wish to show this by showing what the NPA told the Supreme Court of Appeal in the case of Schultz. And the citation there is Schultz versus Minister of Justice and Correctional Services and others, 2024, ZACSA 77, that's 23 May 2024. And the third respondent in those proceedings was the Director for Public Prosecutions, Local Division, and the fourth respondent was the National Director of Public Prosecutions. My Lord, if I may beg leave to hand up this case to my Lord while I refer to the relevant paragraphs.
Thank you.
Now, if we look at page 6, my Lord, that page 6, paragraph 9, the Supreme Court of Appeal tells us there that there's a Mr. Bortes and a Ms. Leroux who filed affidavits and explained the current procedure that is followed in giving effect to an extradition request from the Republic to foreign states, including the United States. And it states there, they described substantially the same process. It is the individual prosecutor who initiates the request by identifying the need for extradition and preparing the relevant documentation. This includes, as part of the treaty, a warrant of arrest and a charge sheet. These preparatory documents are forwarded to the Deputy Director in the DPP's office in charge of extraditions. If he is satisfied that the documentation is correct, it is forwarded to the DPP, who signs off on the final document. It then goes to the NDPP for her perusal, and if she is satisfied, it is forwarded to the Director General. Mr. Bortes and Ms. Leroux described the DG as being the designated central authority for extradition requests. And then later in the same judgment, we look at page 22, paragraph 44. Now, this would be the legal conclusion that the Supreme Court of Appeal reached, but that is not the point of my point in pointing to this paragraph. It's the second sentence, which states that as things currently stand, there is no identified functionary, even within the National Prosecuting Authority, who exercises the decision-making power to make the extradition request. Is it the prosecutor or the DPP or a functionary within the NDPP's office or the NDPP herself who does so? The respondents do not tell us, nor does the NPA Act. And I'll deal with the legality of the National Prosecuting Authority being the functionary that was making this request, my Lord. But the point being that the National Prosecuting Authority was able to explain to the High Court proceeding, as well as to the Supreme Court of Appeal, what processes followed in the making or the requesting of extraditions to foreign countries. They set out who the people are, what happens, and how it goes. But before this court, when it was imminent and pivotal pivotal for them to do so, they did not place a single person who could speak to this in this box. Instead, they put individuals from other departments who had nothing to do with extraditions. And so the point still stands. The state did not put any evidence, or rather relevant evidence, before this court in relation to the legality or lawfulness of Ms. Chilota's extradition. Now, on Schultz, my lord, we also then see perhaps why the National Prosecuting Authority or officials from the National Prosecuting Authority would be reluctant to be in this box testifying as to their actions or the legality of Ms. Chilota's affidavit. The entire judgment that the Supreme Court of Appeal handed down in Schultz basically makes clear that the National Prosecuting Authority has no place in making or requesting extraditions, as they are not part of the executive. The relevant paragraphs, my lord, if I may, is paragraph 29. This here, the judges of appeal, or the justices of appeal, they confirm that although Kuwanda, of course, the case Kuwanda, does not deal directly with extradition powers, it confirms that the state conduct, it confirms that state conduct implicating foreign relations falls within the ambit of the executive authority. And on the following page, that would be paragraph 29, that is in the middle of the paragraph before the article in the Vienna Convention. It states there that when an official makes undertakings on behalf of the state or performs such acts, he or she must have authority to do so, and such acts have a binding consequence for the state. In other words, the individuals that were requesting Ms. Chilota's extradition, such as Advocate Dinesh, such as Ms. Navila Somaru, ought to have had the authority to do so. And Schultz tells us they do not, because they are not part of the executive. And the following paragraph, they explain why. At paragraph 32 on page 17, the Supreme Court states there, to hold, as the respondents argue, that it is the NPA and not the executive that has decision-making power in respect of outgoing extradition requests would be contrary to established international law principles. It would accord to a non-executive domestic organ of state. It would accord to a non-executive domestic organ of state an executive function at a state-to-state level. Now, this is what, my lord, they could not come before this box and tell you, because that contravenes the doctrine of separation of powers, which the Supreme Court also states that they were, in making the requests for extradition to America, in submitting further information to America regarding they were actually going outside of the bounds of the acts or the conduct that they can, as they are not part of the executive. The case Quagliani that is stated at paragraph 33 of the same page, it states there in the middle, it should be added that although the power to request extradition to the Republic from a foreign country is not expressly provided for in the Act, it is necessarily implicit in sections 19 and 20. And on paragraph 34, the following page, Quagliani thus confirms that under the Extradition Act, it is the executive that is empowered not only to respond to an incoming request for extradition, but to make an outgoing request. Importantly, the judgment recognizes that the absence in the Extradition Act of an express power on the part of the executive to make an outgoing extradition request does not signify an absence of that power. The executive power to make an outgoing request is to be implied from the principle of reciprocity, which lies at the very heart of extradition. Very importantly, at paragraph 35, regarding the National Prosecuting Authority, the National Prosecuting Authority's interpretation of sections 179, it states there that the respondent's interpretation of section 1792 is tantamount to suggesting that the NPA has the power to conduct foreign relations and to bind the Republic on a state-to-state level. This is inconsistent with the principles articulated in Kaunda and of customary international law. It is also inconsistent with the separation of powers and the constitutional recognition of matters involving foreign relations as falling within the preserve of the executive. And finally, on this Schultz matter, at page 19, paragraph 37, the final two sentences, in fact, it would be constitutionally untenable to have both the executive authority and the NPA exercise this power. This would lead to South Africa speaking with two voices in the conduct of its foreign affairs in relation to extradition, which is an undesirable consequence. And when one has regard to when the judgment was handed down, my Lord, it was heard on the 15th of March 2024, and it was handed down on the 23rd of May 2024. This was when the extradition proceedings in the United States was underway, which means that at any time, the state prosecutors and the National Prosecuting Authority could inform the U.S. that in fact they do not have the authority vested within them to make this extradition, and perhaps do what we were asking Captain Collins and General Kharba the entire time. Would it not be best simply to request Ms. Cholada to return to the Republic? And so had they simply just done that, we would not be here. But they persisted with an extradition, and we will show now that how they persisted after January 2023 with the procurement of information that was not correct from both an independent company, forensic auditing company, as well as in their own affidavits that they later submitted to the U.S. courts, that that information itself were misrepresentations. So not only did they not have the power in terms of the law to make the request, in making the request, they provided information that was false and incorrect, and they knowingly did so. And so I will now deal with the aspects of the extradition that render it such that had the United States known that what they were looking at was incorrect information that was intentionally supplied to them, we stick with intentionally, the misleading or unintentionally misleading after the timeline that I've just shown the court cannot stand. It was an intentional act. They knew what they were doing at all times. And so on the part of the evidence that the state ought to have placed before this court by way of any individual from the National Prosecuting Authority, and we know they're right across the street. They could have come to this court and set the record straight. This is what we did. This is what we followed. This is the act. This is the authority that we have. And according to us, this extradition was lawful. Instead, we had members of the South African Police Service telling this court that they were not sure about this. They were not privy to that. Yes, they were copied in this communication, but they're not the ones that were responsible for that. And at all times, if memory will serve us correctly, Advocate Captain Collins said it was the Office of Advocate Nation that had made requests to the United States, and Brigadier Kharba or Major General Kharba confirmed it, and he singled out Advocate Nation as a person when he was questioned as to whether or not it was the office or it was the individual. And so it was known by all and sundry which office and which individuals had made the request to the United States, and it would have been proper for the state and National Prosecuting Authority to bring this court into its confidence and tell this court how it went about this extradition in order for this court to make the determination correctly whether or not that was lawful. But they did not do so. And the case that I cited earlier, Rex versus Khadeb, 1945, as far back as 1945, it has been that it is the prosecution that bears the onus to establish jurisdiction. And so their contentions that because we did not place Ms. Chilota on the stand, that might be fatal to our case, cannot stand. They do not hold water. It was their case to prove, not our case to make for them to disprove. The onus rests on the state and the prosecution, and they failed to discharge that onus by failing the most preliminary point of bringing witnesses before this court that could attest to what we were saying was an unlawful extradition. And so on that part, Lord, we then now deal with the incorrect or misrepresentations of fact in what they ended up supplying to the United States. And so it will be recalled that we handed up a summary by the magistrate of the information that she had considered in coming to the decision whether or not to certify the extradition. All of the 9 points, all but 2 of the 9 points, were procedural points. Whether the Ms. Chilota that was before her was the Ms. Chilota that was stated in the papers, whether the court had jurisdiction, whether the arrest had been lawfully made. And it will be recalled, my lord, that the final 2 points were A, that was point number 8, whether there was probable cause, and number 9, she stated there, and if I may find the exact one so that I can read it directly. The 8th was there's probable cause to believe that Selina Chilota before this court, the same person identified in the extradition request from the government of South Africa, committed the offences for which the extradition is sought. And then she qualifies. She then qualifies what she stated and says the evidence before this court is sufficient that Chilota's committal for trial on the charges had the accused of having committed occurred in the United States. This finding rests upon the documents submitted by the government of South Africa in this matter, including inter alia, affidavits from the South African prosecutor and the lead investigator, the indictment, and a financial forensics report. Now, it will be recalled that questions to the first witness, Captain Carlitz, all led to him conceding that the affidavit that was submitted by Advocate Inyesha to U.S. authorities was after the letter of January 2023. It was dated August 2023. The charge sheet was amended after, and it is stamped 21 October 2023, and the FTI consulting report, the financial forensic report that is referred to herein by the magistrate, that was done on 6 June 2023. Now, this is what that tells us, my lord, that the U.S. recorded that up until January 2023, none of the information that South Africa, by way of the National Prosecuting Authority, provided to it was sufficient to sustain Ms. Chilota's extradition. In fact, they say clearly in the letter, they state that that would be at page 3 of the same letter under tab B, my lord. That would be the second paragraph under OIA preliminary analysis, and it would be the sentence right in the middle of that paragraph that starts with aside. And it states there that aside from her position as the Premier's PA, there does not appear to be any evidence to support knowledge and intent on the charges. A U.S. court will not find her position in and of itself to form the basis of her knowledge and intent on the requisite elements. Considering only the elements of the concept of common purpose under South African law in determining whether there is a sufficient basis, we do not believe it is probable to support August 2022 in the material that we were provided on 11 October 2022, or in the material that we were provided in 30 November 2022, or 12 January 2023. And so on 6 occasions, the National Prosecuting Authority attempted to place information before the U.S. court that there was valid or there was a factual basis to extradite Mr. Chilota on 6 occasions. They did not succeed. And then the documents that they do succeed with are the documents that have got false allegations in them, that have got exaggerated facts, such as the fact that in the FTI consulting report, Ms. Chilota and Mr. Mahashule were expropriating the bursary monies without any proof thereof, just by the statement of it in the report. And other various information that was put to the witness that could not come up with any factual basis to it. But that is what we saw. We do not have anything from the state that says that that provided to the state prior to the state that they did not have factual. As it is, my Lord, in Africa Donations affidavit, that would be under tab C. This would appear from pages 3